wanted to show you this particular one here. This will be on your CD. I actually wrote this for a fellow, and then we never had a chance to use it. But what I was wanting to show to you, now that it was brought up, was the concept of amicus curiae, because that's how I'm appearing in this matter. I'm coming in this way. First off, I say I'm a man, but I'm a friend of the court. I mean no harm. Then I go through all this gibberish here. But let me get down to the part I really want to show you. All right, got a definition. And here, yeah, here's an interesting thing here what I did. I went and said that I have an interest in. See, so I'm coming in as an interested party. I have an interest in this. Here's what I wanted to show you. Was I wrote a bond directly into the pleading. Now, I didn't create all these words, and as a matter of fact, whoever created all these words and everything did a very good job. But this is a letter of stipulation and undertaking. Maybe we'll just read it and we'll go over it a little bit. Yeah, letter of stipulation and undertaking, for and on the record. I am not in receipt of any bond record to initiate the matter or answer the matter regarding case number, whatever it was, and associated matters. Therefore, I, the man, Winston Shrout, state the following. This is my firm offer to pay any and all costs lost by the court and the respective citizens thereof in case number such and such, to be determined by the appropriate officer of the court to indemnify this court and other respective actors. That's what they are, they're actors. The amount of this undertaking to be determined by the judge of the court and entered by the clerk of the court for this bond to be properly credited. The amount to be filled in and this bond returned to the trustee maker for the proper accounting, crediting, payment. The court is requested to respond in 10 days of presentment of this bond so that Winston has 30 days after receipt to enter payment. The intent is to ensure that this court and all respective actors are properly indemnified against any potential loss due to this action of Winston Shrout amicus curiae, with any understanding that this bond should issue in lieu of arrest or detention of Winston due to said plaintiffs or defendants by any injury pursuant to general maritime law and applicable statute law in the form applicable, blah, blah, blah. So what I did basically there was to insure myself, so I could go in down there and talk to everybody without any kind of fear whatsoever. Because I'm indemnifying, I'm saying to them, hey, if what I say down here causes any of you actors any kind of problems, let me know, and I'll make it good to you. Which in my case simply means bring your claim, and what will I do with your claim? Accept it for value and return it to you. So go ahead and bring all your claims you want to, because that's exactly what's going to happen. But anyway, in this particular court plea, what I was trying to show you, you can go ahead and just write a bond right into the thing, right into your pleadings and so forth. You don't have to have all these separate things going on. So let's see, this particular one is about involuntary servitude and peonage. You guys might want to read some of that law there. There's pretty good doctrine in there about all that. So, you know, just to read the thing will give you a pretty good understanding of some of those things. Yeah. Let's see. All right. Yeah, that's pretty much. That's all I wanted to show you. Really, was the amicus curiae concept and the other deal. All right. Now let's go a little bit further with some of these remedies. I want to bring to your attention. Oh, there's one thing I want to bring to your attention here, and that is, all right, this bond right here is very similar to a promissory note. Now this particular bond here is a takeoff on something some of the other brethren did, but we have used these things a couple of times with success in IRS matters and with court matters. But anyway, this one here looks like it's written to the Internal Revenue Service, wherever. So you can kind of read through this. Bond to discharge attachment for debt via pass-through account, John H. Smith. They give the account number. In this particular thing, we wrote the bond out for $1 million because it. Let me give you the. When the IRS sends you a bill, you have no idea what's behind it. You have no idea. And it's kind of like, an iceberg that floats in the ocean. Really, you see a small portion of the iceberg, but what's down below you can't see. And so this is pretty much the way it is when the IRS or the RCA sends you some kind of bill. It's the tip of the iceberg, literally. And so it doesn't hurt to write the numbers very large to cover the thing, because remember, it's only in the accrual. But you have to have sufficient numbers to do a set-off against their numbers. And so you could write it for $1 million, you could write it for $1 billion. What difference would it make? It's all in the accrual. Anyway, so I, John A. Smith, principal, surety, is held and bound to effect payment. Now, that word effect payment, what that means is basically to adjust the account. Because we know we can't really pay anything. That's why I say I'm going to effect payment, which means I'm going to settle and adjust the accounts. So to effect payment to Henry Paulson, Secretary of the Treasury, and to James Jones, Revenue Agent for the Internal Revenue Service, the amount of $1 million, unless the pass-through account shall satisfy any judgment which may be recovered against said pass-through account by Henry Paulson. And so what I'm saying is that I, the man, will be bound in the event that the money runs out down at Treasury. That's what I'm saying. And so probably it's not going to run out down there, because we've been putting all these bonds and stuff in here for a long while. Anyway, back down to the bond order. Here's the instructions. Negotiate this item through the back office for settlement via the pass-through account, John H. Smith, 1234, at the Treasury window, Department of the Treasury, 1500 Pennsylvania Avenue, Northwest, Washington, D.C., for the settlement and adjustment of the IRS presentment, which was letter 1058, blah, blah, blah. A dishonor of the above bond is violation of the national bankruptcy. Then we went through all the rest of that little signing and so forth down there. So here's one example of a bond that's used as a promissory note. So this has been effective. We've used these. All right, then let's get on to first off, any questions about this? I shouldn't really run away from it until we had a chance for everybody to talk about it. Okay. Then let's go back to promissory notes in general. Now, I want to show you. No, that's not the one I wanted to show you. Oh, here's the one I want to show you. Go ahead.
Winston, just to go back a little bit, when you go into court as an interested party, you're going into court to help someone else out? Or
no, if I go in as an interested party, I'm going in on my own account.
On your behalf, okay.
Amicus curiae is as a friend of the court.
Okay. So the amicus curiae, you would be helping someone,
well,
or is it for your own benefit?
To be helping somebody else.
Okay.
If you're trying to go in for your own benefit, then you would go in as an interested party.
Okay. All right, thank you.
Either as an interested third-party intervener or as an interested third-party intervener under injury. Now, let me explain to you that all the colorable courts operate in fraud. Get it in your, it's a fact. Get it in your mind. It's fraud. They all operate in fraud. And so, there's nothing wrong with fraud unless it injures a real man. Now, if you determine as a real man or woman that you are being injured by the fictional court, then all you got to do is go down there and tell them to stop it. Pay me my injury, and then you go right back to fraud if you want to. But what you just said, what you just did has injured a man. You cannot do that. Pay me the damages. I'll leave. You go right back to whatever you're doing as long as you don't injure me again. See what I mean? And so when you come in as an interested third party, or as you come in as a third party intervener under injury, you're coming in to stop what they're doing because it's causing you grief. So, yeah, it's not uncommon to go into a court and simply address the court, hey, I'm here as an interested third party. And here is my claim. Here, I brought this in here. There's a whole doctrine of law about third-party interveners, about intervention. Who is the most common third-party intervener in the court?
The IRS. The IRS.
No.
Judge.
No. No. Queen. The Queen will always come in and protect her interest. And what allows her to come in? No.
She has a claim.
Because you're using her image in your dealings. You got her, what did Jesus say? Render unto the Queen whatever belongs to her. And so, anytime you get involved in a court situation where this has been used, then the Queen can come in as an interested third party. They do it all the time. So how do you keep a third party out of your contracts? Don't use their money. Uh-oh, got him stirred up now. And him too. Holy cow, now we're running in trouble.
When my wife came down to post bail, could she have used a promissory note?
No, I don't think a promissory note. She could have used a bond.
If we had that in place then?
Yeah.
Okay, so it would be a copy of what you had sent off, or you worded differently?
Yeah, you heard what he did with his indemnity bond. As soon as they found out that indemnity bond had been faxed in the affidavit and so forth, they said, hey, we got to get rid of this guy.
Oh, okay.
But you can give him cash for bail if you want, but remember that's all it is, bail.
I looked up CSIS on the net and
Looked up what?
CSIS. That's what's that?
Security Intelligence Service.
Yeah, it's kind of like the FBI.
Okay.
So anyway, I looked into their mandate and the act which gave them their authority, and it said that they were there to protect the Queen's securities, or the crown of the crown. So it said that you were anyone who used violence to overthrow the Canadian government, all this stuff, and it says, but it says also at the bottom it says except you may overthrow the government using peaceful protest. It says right in there.
That's UCC doctrine, of course.
Yeah.
Okay.
As long as you're peaceful. But who would want to overthrow the government?
Exactly.
Yeah.
Why?
What the hell, man? Excuse me. Let's say, let me retract. It doesn't make any sense to overthrow a government. I mean, what are you going to replace it with?
Same thing.
Same thing.
I always do.
All we do is why you want to overthrow the thing for? Now there may be some parties in the government that you might want to find a new job for. Now there's one fellow I met. He got jammed up on some foolishness, got put into the Bureau of Prisons, and by the way, he's the only guy I know ever got himself out. But what he did, he told me, he said during the process of getting myself out, he said I had 3 wardens fired and 37 BOP officials fired. So I'm saying, what did they do? Get tired of you to kick you out of there or what? But anyway, he left a swath behind him when he came out. But that's what I'm saying to you. He found people in that system who were corrupt and who were not doing their job. He got them into a bind, and he hit them. And out they went. They found a new job someplace. And so, by the way, if any of you are interested, I asked him, how did you actually accomplish getting yourself out? He said just did a standard mortgage foreclosure. Well, okay. What he did, he went and published in the paper, appointed a successor trustee, had the successor trustee go in and liquidate the court case and basically tell the clerk to release the sureties. And they did. Anyway, go ahead.
Early on the weekend, it might have even been Friday, you mentioned the necessity to take your commerce to the international. Now, this was going to be one of my questions I wanted to bring up.
Okay.
And I thought I'd bring it up now because you're getting into promissory notes.
All right.
I'm sure you're familiar with the principles of UN Cetral.
Of what now?
UN Cetral, United Nations Convention on International Notes.
Okay, yeah, I'm familiar with some of that.
Okay. Do you endorse that type of method for making your promissory notes, and would that be one method of taking your commerce international, so to speak?
Yeah, I don't have any problem with them. I mean, they're just another corporation, so we can do it that way, or we can do it others. I would personally prefer to create my own law, and then just work in connection with that. But go ahead.
Okay. Well, I bring it up because you mentioned, as I said, the necessity to take your commerce international, and I was hoping we might touch on that at some point. So I thought
Okay.
this might be a good point.
Well, I don't know a whole lot about those conventions. I have looked into the what they call them, Unicitral. Yeah, I've looked into all that stuff, and it didn't make a whole lot of sense to me. So I kind of went this other way by doing my own thing, as it were. Let me also say that if you're involved in commerce, you're involved in the international, by definition. Commerce has to do with business across political boundaries. And so if you leave BC and go to Saskatchewan, you're involved in international because you're involved in commerce. Because you just crossed a political boundary. The word trade refers to, doing things inside of a political boundary. But once you cross that, now all of a sudden you're involved in commerce, and so that does denote that you're involved in the international. So, like I say, I have read some of those things, and I didn't fully understand them, and so I didn't spend a lot of time on them. But we can talk about what I do understand a little bit about. Now, the reason I put this one up here, the reason it's included on the CD we have for you, is the guy that wrote this understood it. He understood it very well, and all of the law involving itself with tender of payment, he wrote in this thing. And so it starts out with the promissory note itself, then it runs down into offer performance. Anyway, I think it's about, I got 14 pages of it, I guess. But anything you want to know about promissory notes and tender of payment law is right there. So familiarize yourself with it and learn it. Okay? Go ahead.
Just going back to your buddy that was in prison that took down the wardens and the officers, how does that work? Say if, some government officials that are just after you constantly, is there how do you go about that?
Well, I would just trump their bond. I'd write a bigger bond than theirs and then go seize theirs, replevin it.
So if you just take their bond, I got some issues with a bunch of RCMP. Well known, they got a restraining order against me. I can't talk to any cop in Canada. So
the question that follows is,
So I'm
why would
wondering-
you want to talk to them?
Well, no, I know, but just there's a couple handfuls that are making my life miserable with all the stuff they got on CPIC on me and everything. I'm just wondering, how would I go about to obtain their bond?
Well, you can either go and find their bond or you can go write one for them.
That's what I was wondering, if I just do their name.
Because probably you can write a bigger bond than what they have. And so you might want to go in and put in an indemnity bond for them, let's say the United States Treasury, and give them notice that you put that bond in for them. And now when now you're in position under subrogation to instruct them what to do. So then you say jump, and when they don't jump, then you go and liquidate the bond. Now, when you liquidate the bond through Treasury, the Treasury will send IRS out to go collect the money.
Sweet.
And so when they find out that the particular individual's bond is not sufficient to cover the bond you just liquidated, now they got a problem.
Okay.
So they're you probably only do it once.
Once would be enough.
Once would be enough. then after that, I don't think you're going to have a whole lot of problem with it.
Right on. Hey, thanks.
That's one way to do it.
Can the IRS actually come up here and collect?
They don't have to. They got computers.
That's right. That's right.
They collect from right where they're at, right downtown in Washington, D.C. They won't leave the office. They'll be sipping on a cup of coffee while they do it.
But they can collect in Canada.
Yes.
Oh, yeah.
Collect anywhere in the world.
Anywhere you see an FRN, they can collect because they're a third-party intervener. They're there to protect the interest of.
We're all part of the Queen.
That's right. The United States is still a British colony.
When you liquidate somebody's bond, do you actually, is there money in your account now? So how does that work then? Where does the money go? Or what happens? I don't
Okay,
get
first
it.
off, remember, it's not money. It's in the accrual, and so they're only
yeah.
adjusting the account. So let's say, for instance, that you wrote out a $300 million bond against certain corporate entity over here. Corporate entity dishonored you, so you go and liquidate the bond. You put in the proper paperwork to do that. We got that for you. You can see that. Matter of fact, we need to go over that probably. Everybody seems to be so excited about that. Anyway, you go ahead and liquidate that bond, and then it's all a matter at that point of adjustment. And so that's why I was saying a while ago that don't be surprised by the size of the numbers we use. That's not uncommon. And so when we want to go do a certain, like for one time we went and liquidated a judge for only $3 million, and we're thinking, oh crap, man, we didn't get rid of the guy. He got him off the case, but he didn't lose his job over it because $3 million was not a hiccup to his bond. That bond that one other fellow did for $9 billion did not cause a hiccup with that federal judge. He could take a $9 billion hit. So the numbers that we're using here are not unreasonable. See what I mean?
You made this statement a little while ago, and I've been looking at it, and I just feel, in my ignorance, I have to ask it.
Okay.
It says there's nothing wrong with fraud unless it injures a man.
That's correct.
Okay, so if I'm charged with fraud, and there's no injured man, and I inadvertently, through ignorance, plead guilty to it, can I go back on the cop that is responsible for bringing this all into place?
Well, yeah, you can do it anytime you want to do that.
Okay, he stole my guns and various other things from my home, and so I could actually go after, it's sort of vengeful, but go after this particular cop and his superior sergeant, and with a bond and make these guys do what I want them to do, return my unregistered rifles.
Well, it's going to be a fight, but you can do that. Let me explain to you a little bit further about bonding of public officials. And that is, each office has what's called a scope of office. And it says what that particular employee can do. And the insurance company will only bond those particular items. For instance, if you're a policeman, if you're a nurse, if you're a bus driver, each particular occupation is going to have a scope of office that describes here's what a policeman does, here's what a nurse does, here's what a bus driver does. These are the things that are insured on this policy. Therefore, they are only insured to do what is right. If an officer or a nurse or a bus driver, for instance, if a bus driver decides he wants to drive a train, If the nurse decides that she wants to be a psychiatrist, if the police officer decides he wants to be a pirate or a thief, those things are not covered under their bond. So they are upon their own private liability when they do that.
So one needs to get the scope of their office under the
Yeah,
insurance.
just go down and find out, that, every time somebody gets hired on to a job, they give them a little booklet, say, here's what you can do. That little booklet will describe what it is that their job description. And that's what they're being bonded for, is their job description. So then, once you find out what that is, and you determine that they have gone beyond their job description, now they're on their private liability, their bond will not help them.
I just have friends of mine that are the sovereigns that have had letters from Canada in relation to firearms as well. So he probably got the letter too of that offer as well. So if you don't respond to the offer, they'll come and get it from you. So it's probably good to remember that every piece of pirate mail you get is an offer.
Yeah.
If you're not doing nothing with it, you're creating the problem. So it depends, right? Was it just taken, or in most part they'll have to give notice in relation to the firearms.
Okay. Hold on a minute, he's going to ask you a question.
So they get a warrant for a fishing expedition into my office and my home, and in the process, they go to this cabinet, which isn't to the regulations, and they take them. Now then, the only way I can get them back is to register them, and I don't even know then if I can get them back. And it really isn't that I'm that hung up on getting them, because my better equipment was someplace else. But there's one particular item that my wife gave me for a birthday present many years ago that I'd like to have back. So they, under color of law, they were committing fraud to get that warrant in the first place.
Mm-hmm.
So this all ties together, and I
So
appreciate.
the fraud did cause an injury to a man, so now you have to tell
Their
him to stop
fraud
and
caused
correct it. That's correct.
an injury to me, but my fraud to the bank of $700 didn't cause an injury to anyone.
No. Because you're dealing with a corporation on that. Uh-huh.
Yeah, and he's right here. Happened to help a friend of mine as well in relation to a matter, and at the end of the day, this small little pocket knife, I guess, that they came by and returned it and had the offer again, and they said, well, you guys are, and basically you guys didn't itemize that anywhere, and now you're trying to give this offer back by just coming some ungodly hour to return it to him. So you have to be careful too when the stuff is coming back in relation to accepting that back, and know what to do with it.
Okay. Yeah, you'll find out that what we're talking about here is a way of life, and you need to become proficient in this way of life in order to find the success and happiness you want. Okay. By the way,
Winston,
this is a school marm.
you weren't supposed to tell anybody.
I forgot
I
to
just
bring an apple
retired.
today.
It's okay. I'm back into the
Okay.
better place. Earlier, you had been talking about how to take the bonds of a judge or someone else, and you had said, well, write a bigger bond, and that will subrogate them. Why will they not just turn and write a bigger one?
Because they don't know how. They rely upon an insurance underwriter. And the insurance underwriter is not going to risk very much for them. For instance, we have not talked about limited liability insurance yet, which we need to get into. And I probably ought to do that before I get into promissory notes. But anyway, okay, let's get into limited liability right now then. Okay, take this question.
Quick comment?
Sure. Uh-huh.
This is from my many years' experience in government. Because the government is partnering with private corporations, okay? it makes everything that Winston says even more interesting for me, because those corporations are very careful about what liability they incur in their partnership with the government. So that if you know who the partner is in the particular area that you're working in, whether it's health or medicine or whatever, you really can limit what the officer will do, because his partner will
Well,
say,
not
my
sure.
insurance company ain't going to cover that.
Exactly right. Okay.
Just a quick note, going about the guns, and I don't, this is all third-party information, so I don't know it to be factual as of yet, but it was told to someone by a police officer, if they come in to take your guns or doing any of that meshing, and you're not correct and you don't have an FAC, they'll come in and do that. There's supposed to be 3 days that you can sell those guns to a friend or quote whatever, and they will return it to them. It's just a point. Now, somewhere we got to look this up in the law to make sure that it's factual, but I was told about that and I still haven't found it yet.
Okay.
The friend will have to register.
He may have to register them at that time, but at least you don't lose your gun. Like I had a friend that, well, it was a friend, acquaintance, lost a whole bunch of guns, and some of them were heirlooms from grandfathers and things like that. They lost them, and we only found this thing out afterwards. Now we're still trying to do some work to get them back. But
Okay.
Make it a gift to a sovereign and you'll get them back.
there you go.
Yeah, limited liability. Back in the early days when we had sailing ships that went across the ocean to carry cargo and so forth, there was
Winston.
okay.
I just interrupt for a second. I'm a professional accountant, have been since 1979. I used to be a certified general accountant until the year 2000 when I saw the light and opted out of that whole scheme. I still do tax returns for people and get lots of money back from them, and they really got a thing in for me. But that's okay, because I like to deal with this. But I thought maybe after lunch, if anybody's interested, I can go into a little bit more detail and clear up any misunderstandings about what you refer to as the accrual accounting system, which is really called double entry bookkeeping.
Yes.
And I'll show you how it can be manipulated very easily. It can be manipulated by any accountant who knows what he's doing, and certainly any bank. And then I'll go into accrual accounting for a little bit.
Okay.
That gives you a little better idea of what they're doing out there.
All
And
right.
how
We can do
you
that.
can kind of overcome that, so that you understand what double entry bookkeeping is all about, how it works, and how it could work for you. Okay?
All right.
And that should only take maybe 15 or 20 minutes.
Okay, we'll do
Maybe
that.
after lunch?
Yeah.
Okay, thanks.
There we go. We like volunteers. Now, so let me explain to you a little bit about limited liability. And you can see the effect of coming out of limited liability into full liability. Now, I myself like to operate with full liability when I'm in commerce, because that precludes any corporation from making any claims against me. Because when I come in under full liability, they can't match it. They won't come in under full liability. And by the way, limited liability is a benefit privilege. And so I don't like using their benefit privileges either. But anyway, the history of the limited liability was that the ships going across the ocean were in peril. And so you understand that insurance is necessary under the Admiralty because of the possibility of loss of cargo. If you're in a wagon train going across the land and you have a load of gold and your wagon breaks down out in the middle of the desert someplace, you can still recover the gold. However, if a ship goes down in the banks out, St. George's banks, it ain't coming back up. And so the gold is permanently lost. And in consequence of that, if the ship owner had to bear the full liability, it would be unprofitable to be a ship owner. And so they had to limit the liability of the ship in order to encourage shipping, or nobody would have done it. So in 1851, they came up with the Federal Limited Liability Act, and it was amended, several times and so forth. Anyway, what it amounts to is that the ship's owner has limited liability because the rest of the liability is picked up by an underwriter for a premium. See, it costs for insurance. Now let me give you an example, one that you're all familiar with, but you probably have not realized.
Is that why the captain of the ship would go down? He wasn't covered?
I don't know that. I don't know that. Let me read this little short article here. It says one of the unique aspects of maritime law is the ability of a ship owner to limit its liability to the value of a ship under a major accident. An example of the use of the Limitation Act is in the sinking of the RMS Titanic in 1912. I think y'all familiar with Titanic, saw the movie and all that. Even though the Titanic had never been to the United States, upon her sinking, the owners rushed into the federal courts in New York to file a limitation of liability proceeding. The Limitation Act provides that if an accident happens due to a circumstance beyond the privity and knowledge of the ship's owners, the owners can limit their liability to the value of the ship after it sinks. After the Titanic sank, the only portion of the ship remaining were 14 lifeboats, which had a collective value of about $3,000, and the pending freight. In other words, there was pending freight in New York for them for the return thing. The pending freight bringing the total to about $91,000. The cost of a first-class parlor suite was about $4,350. The owners of the Titanic were successful in showing that the sinking occurred without their privity and knowledge, and therefore the families of the deceased passengers, as well as the surviving passengers who lost their personal belongings, were entitled to split $91,000, which was the value of the remaining lifeboats and the pending freight. So, does that give you an idea of what limited liability is on the ocean? All right. So, as part of the shipping industry, now it's gotten to the point now where many of the Admiralty lawyers are simply saying, hey, we don't need limited liability any longer because we have communications. In other words, the ship goes into distress, we can have somebody there like that. The Coast Guard rushes out, it's in helicopters, it's in airplanes, all that kind of thing. So a tragedy at sea in our day and age is fairly unlikely. So there's some argument being made right now to stop the limited liability on the sea, but so far they haven't got it on. In any event, the Limited Liability Act was put into effect in 1851 to encourage shipping. Now the limited liability follows after the Admiralty, and since the Admiralty came on shore, now all of a sudden we have limited liability on shore, which absolutely does not belong here. But let me remind you, limited liability is a benefit privilege. And so if you use limited liability, what do you owe to the party who gave the insurance policy? Tax. You owe them tax. How much is the tax? I don't know how much you agree to. But anyway, let's take a typical limited liability insurance claim. Let's say, for instance, you have an insurance company that insures bodily harm. And typically, the claim, let's say for a lost arm, is $1,000. So that would be full liability. So that would typically be what they pay out for the loss of an arm. So you got the 1,000 here. So an insurance underwriter comes along and says, we will accept part of that liability for a premium or for a tax. So in our case, who is it? The United States, or whoever you're dealing with. The United States came along and says, we will take on the burden of limited liability. We will take on the burden to the amount of, let's say, just for a guess, let's say $500. So in the event that a claim comes into the insurance company from somebody that lost their arm, the limit that the insurance company would have to pay would only be $500. And so the government then, the U.S., is liable for the other $500, which will probably mean that the guy ain't never going to see it. But because for each claim that comes in where they have to pay off a claim for a limb, the insurance company just realized a profit of $500, they have to pay the tax on the $500. Now translate that into what you're doing. You're operating in limited liability. And so the government comes to you and says, well, you know what? Even though you have all these huge liabilities out here, we will give you the opportunity of discharge. So you don't have to pay your bills right now. You can put them off into the future. So under limited liability, then you can discharge that debt. But because you discharge your debt, what do you owe to the guy that gave you the limited liability insurance policy? Tax. That's where tax comes from. Is from the profit that you receive from limited liability. See? From whatever source derived. We got 2 minutes? All right, go ahead and change the film then.
Just to give you a little bit of information here before I give you some real good stuff. Kaz of the Christian family. Did I spell it wrong? Anyways, it's much longer than that, but that's precise, concise, to the point. So everybody just calls me Kaz, but I'm not Japanese. Apparently there's a lot of Kazs in Japan. Back in, I got into the game of accounting when I used to work for National Revenue Taxation back in 1972 to 74, and I went into accounting in 74 and graduated as a CGA, or Certified General Accountant, in 1979. And I've been in private practice in Winnipeg and here in Kelowna ever since. It was in the year 2000 that I tendered my resignation with the CGA for a number of reasons, but one, of course, which is ethical. And it was prior to that that I had learned that the Income Tax Act of Canada was unconstitutional, and there's no act that says a human being should be paying any taxes. That was from David Butterfield and his Shareholders of Canada, so I went that particular route. And so I learned a lot over the years, and I've done my share of suffering at the hands of CRA, which I'm still doing now. But with the information this weekend, I think I'm pretty confident that I can sort of overcome that. And I'm going to have a lot more fun, because the more knowledge you have, the more experience and the more falls that you've made and you pull yourself back up again and keep going, the easier it becomes, and the less stressed you are when you're met with some opposition that come around saying that there's some kind of an authority. But all I wanted to do was to clarify a couple things in regards to accounting. Now, once upon a time, prior to the Renaissance, if I can remember some of my history that I learned a long time ago, there was no such thing as double entry bookkeeping system. That's really what Winston has been talking about. He's called it accrual accounting, and I'll show you the difference. It doesn't matter what word you use, except that when you're dealing with some technical language, you should use it properly. because it can be confusing. But back then, they only had single entry bookkeeping system. So in one of the Italian states, or independent states at that time, it could have been through the Medicis, who knows, they came up with this idea of a double entry bookkeeping system. And all that means is that for every, what we call a debit, actually it should be DB, maybe this pen doesn't write as dark as the other one. A debit and a credit. Look at this as a cross. If you want to, you know, Winston pointed out on Friday, I wasn't here yesterday, when you're looking at John the Baptist as this particular dividing line, and Jesus is here, who died for your sins and taught you the Lord's Prayer, which said, forgive me my debts as I forgive my debtors. A lot of religious organizations have transferred that to trespasses versus my trespassors, but it's really debt and debtors. And here the debit system, if you want, is the Mosaic law. You have Jesus' law, which is mercy. This is execution of law. This is, in fact, mercy of law. But look at this as a debit and credit system. So, as Winston said, for every entry you put on this side, whatever it happens to be, it could be things like accounts receivable. It's just basic bookkeeping. I just want to make sure you understand that. Or cash in a bank. Or it could be inventory. Or it could be a truck, which would be a depreciable asset. So if you're going to have an account receivable here, you have to have a balancing entry somewhere. It just can't hang there in the middle of nowhere. On the credit side, you could have an account payable. It usually doesn't happen that way, but it's a balancing entry. From a bookkeeping point of view, this is perfectly legitimate. It may not be accurate, but it's legitimate because it's balanced. Or you could have an account receivable. Well, this would be easier. We've got $10 cash in the bank. Now, either this was a contribution by an owner, so it's a contribution of $5, and maybe you borrowed some $5 or $4 and another $1 from somebody else. So 5 and 5, the bottom line have to match. Or you could have earned over here, which is also on the credit side, but a little further, and it's also split in two, and that's called the income statement. Okay? That's what we call it, but it doesn't matter. Profit and loss is an old term that was used for many years. We now call it an income statement. And here again we have credit, debit. Here are all your expenses, no matter what kind, and here's your revenue. If your expenses are 1, and they could have come from any combination here, but I'm not trying to make a direct bookkeeping entry for every little bit. But if your expenses are 1 and your revenue is 11, you end up with a balance. In other words, you need 10 more units of expenses to match your revenue. So here's your profit. It's 10, right? Because you got 11 minus 1, you got a 10 profit. So down here, your cash could have come from your profit, and that's really part of what they call equity. It's your contribution and your profit. And you have 10. So again, you got a balance. And within this particular system, from a banker's point of view, this is a beautiful system to manipulate figures. All right? So let's just go to what a bank might do when you go in there to borrow some money. And it's all ledger accounting. It's always been that way. And you can create anything, because all it is, electronic or paper entry. When you go in a bank and you make a deposit, right? This is where a lot of people get confused. Why does the bank say that I have a credit? I have a credit in the bank. Well, that's because they owe it to you. So here's the bank. It has a liability to you of $10 because in your bookkeeping system at home, which is you have a $10 account receivable, which is an asset. Okay, and these are liabilities. So the bank says, well, you deposited $10 in your account. Therefore, we, the bank, have a liability to you. We owe you this money. And you on your passbook or your bookkeeping system, you say, I have a debit, an asset of $10, because I can collect this from the bank. Are there any questions so far? Fairly straightforward. So when you go into the bank and you want to borrow money, the bank doesn't have to give you cash, right? At least not normally. And this will be bank 2. Say there are only 2 banks in town. You have a checking account at this bank and you want to borrow from this bank for your house. So what does the bank do? Well, it has to balance its ledger. Internally, it has to balance its ledger. So what it does is it, under asset, it gets your promissory note. You sign a promissory note, and you have to sign it before they advance you any funds. Not after, but before. And there's some technical reasons for doing that. I mean, why would I lend you some money if you didn't sign me a promissory note, right? But should you sign the promissory note after I lent you the money or before? Well, they can't give you anything until you signed a promissory note, because they take the promissory note and they monetize it. So in their accounting system, they say, we have, in effect, an asset. We've got this bond, this promissory note, and it's for $100,000. Now, how are they going to balance that? What do they have to do? They have to create a liability, so now they have, in effect, an account payable of $100,000. Now, if you don't have an account at this bank, they still have a liability. But where does that liability, well, to whom is that liability?
You're going to take it off lead too.
No.
Bank too.
No, you're buying a house. No. We're not getting there yet. We have an intermediary. No, you're getting there. No, they're lawyer. All right? They owe it to the lawyer. It has to go to the lawyer's trust account. You cannot effect this unless you go through a lawyer. So the account payable to lawyer. Pardon me? No, this is going on film, and this is going to CSIS. There are those who think that I'm an agent for CSIS, and I want to make sure that the information that goes to CSIS is correct. So they're not lawyers. I mean, thieves. They're liars. Okay? If you're from down under, you know how to pronounce this very well. Liars. So the lawyer gets his and he's sort of the agent, if you want, and he's got his trust account. And he says, okay, I've got a receivable in my trust account of $100,000, but he doesn't get it at the same time as this is created. This is created first. on ledger, and then this is wiped out by shifting it over to him. He then shifts it over to his liability part, which is actually his bank, when he gives you a check, or maybe goes to the vendor of the property. He gets the check, and he goes to bank number 2. And what happens there? We now has this check, right, which is a negotiable instrument, and he deposits $100,000. And now the bank has a liability to him of $100,000. That's to the customer. So when you have gone over here, this money disappears, ends up in customer number 2. This is all from a technical point of view. This has nothing to do whether it's right or wrong or indifferent. From a technical point of view, that's how it moves. Now, since you drew against this liability to you through your agent, the lawyer, has gone over to the customer, the bank has performed its duty on ledger, shifted the ledger over to somewhere else, has performed its duty to you, its liability, because you've given it authorization by the promissory note, which is not a separate instrument anymore, because I checked that out with the bank a few years back. It's part of your mortgage document. It's buried in there. It's not a separate, here's a promissory note. So that entire document, in effect, is a promissory note, and you promise to fulfill your obligations under that particular promissory note. If you look at Winston's promissory note of earlier this morning, it went on for several pages. Well, the bank does the same thing, only gives you 20 pages, fine print. And the only obligation it has is to take this money and push it over there. The rest of it, all your obligations to the bank, which pertain to repaying this $100,000 at interest rate of 6% per year or whatever. There's your double entry bookkeeping system. This is how the system has to balance. So if you take this idea and apply it to what you've learned this weekend in returns to ledger balancing with your bond, I think that you'll understand that the court, for instance, can't do anything for you until you balance their books with your bond. Then they're shifting the responsibility over to a document, but not to you necessarily, not to you, the human.
Show us.
That's,
Give us an example of that, the lawyers and judge. How do you move a judge into the ledger, giving him the bond?
well, I'm not at that particular point from a technical point of view, because I don't have any knowledge of that. Anything I would say would be speculation. But I want you to understand the basic concept that you cannot have anything that goes on in this life, if you want, unless you have a balance. You can buy anything, you can sell anything, but every time you do that, there's a buyer and seller. Now, I'll give you, I didn't bring it, I didn't think about it, but I came across a situation a little while ago where, and I was planning to use this in a court case, but I'd like to avoid the court case. But if I can't avoid the court case, then I'll use this. But a lawyer prepared a document for a client of mine, and it was having to do with his real property. It was like an easement. I'm not sure exactly what it is, because I'm not familiar with all those terms. But my client signed as transferor and transferee. And he transferred something. And he signed, or the transferor was all caps, and he signed as, the normal John Doe, John Doe. Now, I looked at that and I said, there's something interesting happening here. This is the same person. Artificial entity, all right? The same person. If this was Jane Doe, I could say to myself, okay, the male person transferred something to a female person who happened to be a spouse, I can understand that, you know. I could transfer to you, I could transfer to you. It's not, that's something we can understand, but can you transfer to yourself? But that was a legal document that the lawyer drew up. So it got me to thinking, is it possible from an income tax point of view to be in a document the taxpayer, which is the artificial entity, and the human agent slash representative? And can you in fact transfer from an artificial entity or a fiction to a live flesh and blood and have your signature as or an agent of the taxpayer and as yourself? Based on this, you should be able to do that. Does that make sense? Yeah. But CRA is going after me for creating a document which did exactly that. So that should be an interesting court case if I decide to go through with it. So how is it that this lawyer could do something which to me sounds bizarre, and yet CRA is telling me that when I did the same document transferring from a taxpayer to the human, that was a fraud? Either this is a fraud or they're the fraud.
Second one got my vote.
We've got to have a reason for that, though.
From what Winston said, if the lawyer is an officer on the ship, his word is truth. Is that correct? Except when he's lying.
Well, that's only because he's got his fingers crossed behind his back. Well, if
What was being transferred?
it's an easement on real estate or something. I honestly don't know. I have to come in with a document and, yeah, Mike.
So are you saying that by that document they actually transferred some value out of the public into the private?
I don't think so. I think it went from.
Is this permission to do a thing?
It's something like that, yeah.
That's why the RCA is getting after you, because you're doing something different than what that attorney did.
Something within the, but I'm using their particular rules and regulations, their definitions, etc., according to their Income Tax Act.
But you're not an attorney.
No, I'm not. And maybe that's the difference.
Yeah, you don't have a license to do what they did.
That's a good point. That's a good point.
The other point is that the all caps is a trustee for the Queen, and you, the human being, acting in that capacity as trustee, have to look after the Queen's interest. And so by taking something from her, in a sense, and giving it to somebody else, that's not really for her benefit. And that's why they're going to slap you on the hand unless you've got a really good reason for why you did something as a trustee for her property, for her person, and gave it to somebody else. That's because I've looked at that and I thought, well, why can't I do this and do that and the other thing?
Yeah.
It's like
No,
I asked one guy, and it was actually Russ Perisky, who was telling me, but you're going to run into some trouble with that because who you were being, and anyways, you got it.
Yeah, I understand that. And I mean, we could have a long conversation and discussion of why I think it's legit and why you may not, etc. The point is that, and I think Winston hit it on the nail, the lawyer has a license to do something which within their system is okay, but I don't have that right, even though I may be right morally or ethically or whatever. Now, there was actually no funds transferred because they never went through with that, so there's no cash that actually passed hands. And that might be a moot point. But I'm just trying to illustrate some practical aspects of that. As far as how the courts operate, what they do on their ledger, I really don't know. If I took the time to research and study what the courts would do in terms of their bonds and the bonds that you intend to place and I intend to place, I could probably come up with the theoretical background for that. But I think if you understand the basic concept of double entry bookkeeping, which is really what Winston is referring to, you understand how it has to balance. If it doesn't balance, it falls apart. So they've got to have something. If they're going to give up something, they have to have something in return. So if they get a bond, which they can monetize, just like the bank did, they can then give you something in return.
Setoff.
A set-off, you know, your freedom or whatever. Now, Winston referred to accrual accounting. Accrual accounting. Accrual accounting, an accrual is simply means that you can create a debt before its time. As an example, whenever accountants prepare financial statements for their clients, they calculate approximately what the bill might be. And let's say the bill is anticipated to be $2,000. So on the financial statements, they'll build that in as an expense, even though it hasn't happened, and although there isn't an actual invoice. When there's an invoice, the accrual becomes an account payable. Okay? That becomes an actual legal debt. An accrual is never a debt. This becomes a debt because now there's an invoice, there's an obligation to pay. An accrual simply means we anticipated an expense, and from an accounting point of view, within the rules and regulations of generally accepted accounting principles, we can recognize that particular expense today because it'll become a true liability tomorrow. From that point of view, your material could be considered accrual accounting, but it's slightly different than the double entry bookkeeping system. And within the double entry bookkeeping system, as long as you're working with paper or a computer, you can move figures all over the place as long as they balance. It's really quite easy. This is why a good accountant is worth his weight in salt. I don't like to use gold because geez, I don't think there's enough money in the world to pay for me. But there's enough salt. Because
Salt is the slave's wage, by the way. That's where salary comes from.
Okay, how about pepper? That's a much better spice. But I'd be sneezing a lot. But anyways, the idea is that in order to effect what you want, we do have the knowledge to juggle the books. Sometimes we have too much knowledge, and guys who are dangerous get to work for Enron. And those kind of companies, and those are the largest CA firms in the world, by the way, who do their audits. So you have to figure out, who's really the criminal there. Are there any questions on this aspect? Does that sort of enlighten you a little bit more on how, the system works, in a sense?
As when you mentioned to monetize the note, like, I've just about every year has gone for a mortgage at one time or another. When that was monetized, and then they lend me the 100,000, they created the money on my signature?
Absolutely.
So they lent
Well,
me
it didn't exist prior to your signature.
So they lent me nothing.
That's a technical thing. I'm not here to debate that.
Yeah.
I'm just telling you that as far as their books are concerned, they balance, and they now have a debt which you signed on.
Yeah.
You came on the train.
So if it created on my signature, then I created the money and they lent me my money. They lent me nothing.
They didn't lend you anything of substance. However, when you go before a judge on your failure to pay the mortgage balance with that argument, he's going to say, did you get your house? Did you not get something? You got to think of a good answer to that.
Kaz, I think one of the little problems is if you look at any of the bank's legal documents, you will not find the word money. Okay, it's just not there because they know there isn't any. And so basically to say that they didn't give you your money, as far as I'm concerned, as far as legal is concerned, that's not the issue, okay?
Yeah,
It
and you're
wasn't there in
absolutely
the
right.
first place.
Because what the banks, if you ever looked at bank financial statements or their advertising, like ING is an example, advertises on television, and you can get a better rate there than you can at your corner grocery bank. They'll say, we have $100 trillion billion in assets. They never tell you that they have the same liability. you know? But they are, it's their assets, their liability is really irrelevant. And the reason is that if you look at a bank financial statements, you can break it down into the cross. You have your asset here, and these are all the deposits in effect. And promissory notes, and you might have some assets such as buildings and whatever. They can do that now. They weren't able to do it years ago. So they always say, here are our deposit, here's our strength, all right? Many companies, in fact, begin to do that now. They say, we have, you know, $10 million under management. They don't really tell you what the liabilities are. And that's really advertising in its extreme. But on this side here, because this whole, see, between Bank 1 and Bank 2, what they have is a balance, right? So they're never out of balance because they know that, what are you going to do with your check? The check they give you through the lawyer is going to go into bank number 2. So even if they were to wipe out anything in between Bank 1 and Bank 2 as a system, their ledger's balance. This is all temporary stuff, but this is what balances, okay? And that's all they're concerned about.
Perhaps in regard to the argument you were making about not getting any money, perhaps a better argument might be in front of the court would be the bank took no risk. And in commerce, if you take no risk, you have no credibility. So in consequence of that, you say this person can't speak in this matter because they have no credibility before the court. They took no risk.
No, that's a good point.
No loss.
If there's any other points that you want sort of me to go over, you could maybe ask me later or something like that. But if there are no more questions, I hope that has helped a little bit, clarify some points.
Thanks, Paz.
My pleasure.
Yep, okay. We appreciate that.
Want to show us how to liquidate the bond?
Yeah, we'll tell you. Everybody gets excited to start talking about liquidating. Okay, test. Everything's working okay? All right. Well, we're always glad when the accountants show up at seminars. I always am anyway. I've had attorneys and accountants show up, and I'm always glad when they do, because it helps to verify some of the things we're trying to accomplish here, and give us more information and perspective on what it is we're trying to do, plus a few definitions and so forth. Okay, everybody wants to start doing liquidating. Is that what you want to do? Or is it, where did we leave off when we started talking? Limited liability. Do you understand limited liability? You got that down in your mind now?
Yeah.
When you're in the public, you operate with limited liability. Therefore, you owe tax on the benefit privilege that you just received. Now, when I operate commercially, I operate with full liability. I don't use insurance. And so I never allow a third party into my contracts. See what I mean? It did me and you. And so when you start talking about these commercial liens and stuff that we've done, there's no limit to liability on the thing. And so you can't back away from it. And that's why those are so deadly and frightening. Like I said, we've had people actually run out the back door of the courthouse to get away from it. Okay. Let me see, I hope, pretty sure. Surely we did. Maybe we didn't. I'm gonna start worrying now. Let me see here. Oh, here it is, okay. Let me get the projector running. Screen coming on. Oh, it's already down. Okay, we'll get the projector running here in a minute. Projector's warming up. The paperwork I'm going to show you now, I did not create. I've been using it for 6 or 8 years now, and some of the wording in there I still don't understand. Some of the guys have looked up some of the words and they can't find them anywhere. So I figure the guy that made this document probably made up some words, which is okay. I do it all the time too. You know, it used to be that all the legal language was in Latin. And so was Mass, by the way. Go ahead.
Now, you just mentioned that under limited liability, so you work under unlimited liability due to the bond. So there's no insurance, no tax, and no third party involved in that. So would you be working as your own individual, or
as a man?
As a man, no company.
Yeah, mano y mano.
Good.
And I may go attach your fictions because I want to loot them, something like that. But let me stay that way. Okay. Well, in regards to Latin, like I made the joke before, if you want to have some fun down at the courthouse, start writing some of your documents in Latin, because the attorneys can't understand Latin. You know, I used to, well, sometimes when we want to have a little bit of fun, we'll put in something into the legal document like, where's that good pen? Where'd that thing go? Oh, here it is. Il minimus se chlor udis. And they would say, therefore, that proves that, blah, 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 blah. Right? How many of the attorneys can read Latin? Neither can the judges. So just write out some wild phrase out there and say, therefore, it proves that, my point. See? Why not? They can't read it. And so then, in the event that some attorney comes along that can read Latin and says, Your Honor, I object, that's not Latin. I say, you're right, it's not Latin, it's Greek. You got to have a little fun, but anyway, some of the words in here, not in the dictionary, so don't worry about it. It's inconsolidation. What in the heck is that? I don't know what that is. Yeah, so here's this word, inconsolidation. Is that a word in accounting? Inconsolidation? Inconsolation.
Inconsolation.
We looked for that, never could find it in place.
Who wrote it?
I don't know the guy that wrote it. I know probably the group of guys that did it, but I can't tell you that I know who exactly wrote it. And I can't contact that group anymore because some of them are stashed away. But anyway, what this is right here, it's a bill of exchange. Exchange. We're going to take something from one place, we're going to put it into another place. All right? In order to do that, what do we have to have? Intermediary to do the exchange. All right? Now, probably in the past, you know, when you've been trying to write bills of exchange and all the things that have been talked about here, you probably were not really doing an exchange. It's probably something else. But in any event, a bill of exchange has to be funded somehow. This is on your disc. Oh, by the way, let's just pass these discs out while we're yammering here. Somebody want to? Where'd my main man go? You want to pass them out? Yeah. Okay. Now here's the CDs. I know some of you have computers. You might want to look all this stuff up. We're fooling with it there. But anyway, you have to find some way to fund a bill of exchange. Because what was happening earlier on, some of the guys were trying to write bills of exchange with nothing to back them. They were trying to write them on treasury accounts and all kinds of stuff that did not exist. And in consequence of that, man, they got thrown right in the slammer for check kiting. Now, I want you to look on this bill of exchange right up front. You'll notice the collateral. That is what funds the bill of exchange, the collateral. Now, it could be anything. In this particular case, it was a presentment by the IRS, which was called Proposed Individual Income Tax Assessment. And that was a piece of paper, it was an actual piece of paper that was sent to John Henry Smith. So John Henry looked at it and said, hey, I can accept this, but guess what? They didn't send a check. So remember what I wanted you to put on the inside of your eyeballs? Your dishonor creates the funds in the involuntary bankruptcy. So this right here is a Chapter 7 involuntary bankruptcy. That's what it is. And so what we're doing then is we're liquidating the dishonorable party. Because under the bankruptcy, if you do a dishonor, you're going to get liquidated. That's why we always tell you when you go down to the courthouse and start talking to folks down there, do not go into dishonor. Don't go into dishonor. Because if you do, you're going to get liquidated, and that's the justification for it. If you go into the court and you never do a dishonor, then they cannot hold you liable for any kind of debt. See? All right. So what has happened then to John Henry Smith here is that somebody in the IRS sent him a presentment that had the appearance of a negotiable instrument. And so he did an acceptance on the thing. And you can either go ahead and do the full acceptance and send it back to them for the settlement when they don't send you the check, all that kind of stuff. Or you can simply, just as soon as the presentment is made, you know there's a dishonor because they didn't send a check. They created liability, they did not give you the remedy. That is a dishonor in the bankruptcy. So, then the thing that funded this non-negotiable bill of exchange was the dishonor of the IRS who did not send a check. Now, typically nowadays, the IRS does send a check. Like I say, man, way back in 2002, we hit them pretty hard. So now they start to produce a check with everything. So, what's that?
Can you explain that?
Yeah. They send a payment voucher. Somebody here had one the other day, didn't you?
I do, right here.
Okay. Can we look at that one?
Yes, you certainly may.
This is from the
Canada Revenue.
CRA, amount owing $13,670.14, and on the bottom of it they gave him a check. Now, what would you like to do with this check?
Accept it for value.
Return it back to him for the.
Endorse it and return it back to them.
Yeah. Will that clear the account?
Yeah.
Yeah, absolutely. Now, what I like to do, they've gone and put the amount owing in there. A lot of times, the IRS or whoever will send you the voucher down here without filling in the amount. like maybe you'll give them, instead of giving them $13,000, you'll send them $1,000 check or something like that, you know. If they leave it blank, I would leave it blank. And I'll tell you why after a while. It'll come up later on as we talk. But in any event, this is the remedy to the top piece. So this right here would not work with this system because they stayed in honor. They did not dishonor. But this is way back whenever. But it could be anything else. It could be anything else. For instance, could it be a mortgage?
Well, they're asking for something.
I hear the wheels turning out there. Could it be a mortgage? It could be. It could be most anything.
Could be my overdraft?
It could be anything. Now, let me explain something to you. Did everybody get a CD?
Yeah.
Way in the back, everybody get one back there? If we have any extra anything, we'll make up some more if we need them. What, he wants two? Let me tell you another story in this regards that goes along with the accounting. That was a friend of mine who was very savvy on banking and all that kind of stuff, obtained some NSF checks from a certain vendor. You know, NSF means non-sufficient funds. So he takes the NSF check into the bank that it was drawn against. He went in and saw the manager and said, here. He said, I've come to get my money. And the guy said, what do you mean? He says, well, here's this NSF check. The guy said, so what? So he says, on the day that this check cleared your bank, did you balance your accounts? The guy said, yeah. He said, then that's my money. Because he was the holder of that check. The guy had to pay it over to him because it was his money. See? And so on the day that mortgage was created, did the banker balance his books?
Yes.
So can you liquidate the mortgage?
Yes.
Because where's the funds at? It's either in the bank or the attorney has it, one of the two. Because they did create the funds because they had to balance. So anytime you find a situation in the public, now remember we're talking about in the public now, anytime you find a situation in the public when a public debt has been created, the offset has been created as well and is being held by someone. And so since you don't know who that someone is to make your presentment to, let's just go ahead and let the IRS figure out who that someone is. Because they'll liquidate it and zero the account out, zero out your debt. You know what I mean? Even if they have to go to an attorney to get it. They have no problem with attorneys. All right, so anyway, let's just pretend like that this presentment that we're looking at up here did not have a check attached to it, so we're going to use that as the collateral. And so when we take that piece of paper and we accept it for value, we turn it into currency because we give it credibility. See? So we're the creditors, we give it credibility, all of a sudden the piece of paper takes on a life of its own and has energy. So that's the funding on the thing. Anyway, we just kind of read through this so you'll understand some of the parts and pieces of it. The invoice up there that you see, JHS 1001, that's just your own device. Whatever it is that you want to identify that piece of paper with, it could be that, it could be a RT number, registered mail number, or certified mail number, whatever you want to put on there. That's up to you. The date, be the date you did it. Registered mail number, if you use registered mail, that'd be a good place to put that, so you can register the document in the public. Now it says this is a non-negotiable bill of exchange. Why do you think it would be non-negotiable? Because it's between the parties. See, it's between me and the secretary. In this case, it was John Snow, but we'll have to update that to whichever guy we have now. We're not really sure Mr. Paulson's still with us, but we'll see. In any event, but it's going to be non-negotiable. Means they can't take it out here someplace else and hold it as a debt. It has to be between the parties. Now, this is in regards to, like I said, this language here, I don't know it all. Don't ask me. Anyway, non-negotiable acceptance of in consideration, that part I understand, and request in consolation in accord with UCC 3-419, HDR 192 of 5 June 1933, and registered adjustment of account. Now, I'm not sure I understand all that. UCC 3-419, I understand, that's the signature by accommodation. I understand that part. But anyway, whoever wrote this knew more about it than I did, and it works. I'm not going to fix it. So anyway, the collateral part you have there. Now, the value of the bill. Now, this is where it comes back to the tip of the iceberg problem. And that is, there is no way for me to ascertain what the value of that presentment is. I have no idea. Even if it has a number on there. Even if they're asking for $10,000, $100,000, I don't know what the liability is. In consequence of that, I never put a value in on that line. I always leave it blank, let them fill it in. Because the IRS will go out and trace it all down, and they'll come back and they'll put a value on that line. Now that value I don't know, but they do. So let's just read through this a little bit here. The undersigned accepts for value all endorsements, considerations front and back, and includes these in accord with UCC 3-419 as evidence with the herein bill of exchange to UCC contract account. Now, there have been some people who had objection to that. If you object to that particular term, take it out. It probably won't affect anything. But anyway, that's the language actually the IRS gave to us back in 2000. Anyway, the herein bill of exchange to UCC contract account numbered. Now this is what we would call our Social Security number, or your SIN number. In the amount listed above, and is part of the undersigned's tax estimate for the use by the Republic. Now, I told you back in 2002 that we had charged back huge amounts of numbers to the Republic. Now, the Republic is on the private side. So when that money was transferred out of the public into the private side, into the Republic, the newspaper came out and said, for the first time in over 100 years, the principal on the national debt has been paid down. The principal. Now see, you can't pay down on the principal from the public side. You can only pay the interest on the public side. On the private side, you can pay down on the principal. So when we went and did a chargeback using this bill of exchange, this is the exact one we used, word for word, folks. When we used this to transfer funds that we had seized because of the dishonor out of the public, we transferred it out of the public, we transferred it over into the Republic, whereupon the Republican government that we still have went and paid down the principal on the national debt. Now, when I saw that happen, I predicted, and I'm a great prophet, I predicted that the interest rate would come down. And it did. Dropped a whole quarter of a point. And so the $400 billion just dropped it a quarter of a point. So can you imagine what it would take to have a real big effect on the thing? But anyway, so this tax estimate is for the use by the Republic, and the account is charged. There's that word charged again. And the account is charged for the fees necessary for securing and registration of the undersigned's rights. And so there's a lot of words in there. The undersigned directs commanding the memory of account number, social security number, charging the same to the debtor's order or to the secretary of the treasury's order. Until then, I am very truly yours, John Henry Smith. Questions? Hey, I didn't do it, man. I'm just using it. And we have used it for, like I say, for 7 or 8 years now. It's the exact same thing. So, now the rest of it, you got questions? Okay, come on up. Uh-huh.
No, you were talking about it being private, and this one has a zip code on it. Does
Yeah,
that make a difference one way or the other?
That should probably be changed around.
Yeah.
So far, we've never had a problem with it, but if you want to be exactly correct, that'd be the best thing to do. Okay?
And this was used also not just for income tax pieces, but, or instruments, but anything else that you're...
Be used for anything. That's why I was saying, the only thing you have to consider is how are you going to fund this thing? The collateral is going to fund it. So any dishonor of a citizen in the public could be used in this manner, and they will go and liquidate. Now, I cannot tell you how long it will take them to do it. Depends on what time of the year is. But don't even hope for anything less than 90 days. Better come up here. Matter of fact, go that way so we don't get into this light here. Our cameraman has been kind of watching us here.
So with that bill of exchange, you can deal with a mortgage, a collateral loan at the bank, you name it?
Yep. Any public debt. Make sure we're talking public debt now. Uh-huh.
So then if you discharged your, well, I hate to use the word discharge, and got rid of your mortgage with that piece of paper, if you turned around and sold your home and got cash back, are you acting fraudulently? Because
why would you? In the public, the only thing you're doing is adjusting the account to zero. Money does not change hands when you do this. Money doesn't change hands. They simply go and adjust the account to zero. Okay?
I believe that's because here you're using money of account rather than money of exchange, correct?
That's right. Just using money of account. That's all you're doing here.
Okay.
Double entry bookkeeping.
Just curious how we decide when we wish to use this instrument, a bill of exchange, as opposed to promissory note. How do we make that choice, that distinction?
Yeah, let me just say, we haven't gotten into promissory notes very much, but we're only tendering promissory notes as a convenience to the vendor. You don't even have to do that, but we're simply trying to encourage the vendor to adjust the account before we have to go to liquidation. That's the only reason we're doing promissory notes, as a convenience to the vendor. Because of the dishonor, we can go straight to liquidation every single time. Okay, just hold this question. He's going to change the tape. Go ahead.